Hi, everyone. Welcome. My name is Megan Sorey, and my colleague Hannah Walsh and I are thrilled to be presenting to you. Before we get kicked off, we just want to make sure that everyone has what they need for access and that individuals are able to see the ASL interpreters and the captions. So if there's a problem, could you please write in the chat or the Q&A section so that we know if there are any access needs that need to be taken care of. And additionally, just as a logistics matter, we will be sending out a copy of the PowerPoint slides after today's presentation. And the slides and this webinar will be recorded and posted on Equip for Equality's website as well. Okay, great. So I think Hannah and I would just love to start off with some brief introductions. I'll go first. Like I said, my name is Megan Sorey, and I'm a staff attorney here at Equip for Equality. And I'm also one of the new advocates on our client assistance program team. And more about that later. We'll talk about that program. I've been with Equip for Equality for about 8 years now, and I've done a whole lot of work during that time, and I'm really excited about pivoting my focus with the client assistance program and focusing more on employment issues to serve our clients. So nice to see you all virtually and looking forward to our discussion today. Hannah, do you want to introduce yourself?
Yeah, thanks, Megan. Hi, everyone. My name's Hannah Walsh. I'm also a staff attorney at Equip for Equality. I've been with Equip for Equality for about 5.5 years. I work on our employment rights helpline, and I also manage our PAPS grant, which is Protection and Advocacy for Beneficiaries of Social Security. The goal of that grant is to help people who are on Social Security get access to employment and to address barriers to employment. So the majority of the work I do for Equip for Equality is employment related, and I'm very happy to be here today.
Great. So I think Hannah's going to start sharing their screen. Perfect. Thank you so much. So the title of this presentation is Your Right to Reasonable Accommodations at Work. So we're going to delve into employment issues and also share with you kind of how that issue intertwines with the client assistance program and our role at Equip for Equality. So next slide, Hannah. So many of you participating today may be already familiar with Equip for Equality, but in case you're not, we just wanted to let you know that our organization's mission is to advance the human and civil rights of people with disabilities. And we do that through providing free legal services, engaging in public policy, monitoring, and providing trainings like the training we have here today. And we're what's called the State's Protection and Advocacy System, or PNA, for the state of Illinois. And all states and US territories have an organization like Equip for Equality to help people with disabilities. And we serve folks with all different types of disabilities. And although our main office is in the Chicago area, we serve folks throughout the entire state of Illinois. And we have 3 divisions or departments within the organization. So we've got a special education clinic that helps students and their families to make sure that they have the supports to get a free and appropriate public education. We also have the civil rights team, of which Hannah and I are both a part of. And we do a lot of the traditional legal work involving disability discrimination issues. And we have the independent monitoring unit that conducts abuse and neglect investigation and goes into facilities where people with disabilities are present. So we're also so thrilled and excited to be presenting this webinar as part of our series with the Client Assistance Program. So for those of you who aren't familiar with the Client Assistance Program, or CAP, it's established by the Rehabilitation Act. And generally, the types of services that are provided through the CAP program are services to people who are eligible for services through vocational services. The CAP program helps folks access services provided by the Centers for Independent Living, or CILS. And also, kind of a lesser known aspect of the CAP program is to provide advice to individuals about their rights under Title I of the Americans with Disabilities Act, or ADA. And this last piece falls right within Equip for Equality's wheelhouse. As a legal services organization, we've been advising individuals about their rights under Title I for many years now. So we're thrilled about the opportunity to be able to continue doing that through the Client Assistance Program. So throughout the country, many client assistance programs are actually housed outside of the state government. And many of them are housed within the protection and advocacy agency. So within the agency that's like Equip for Equality. So up until July 1st of this year, 2022, the CAP program here in Illinois was housed within DRS, the Division of Rehabilitation Services. But now it's been redesignated within Equip for Equality. So myself and 4 other individuals are really excited to be CAP advocates through Equip for Equality on this team. So for those of you who have not heard of the Division of Rehabilitation Services, or DRS, I kind of want to take a brief opportunity to provide some information about the services that this state agency provides. It's a really wonderful organization. So the mission of DRS is to work in partnership with people with disabilities and their families, and to work collaboratively to achieve goals of community participation and independence through education and employment and independent living situations. So DRS is actually housed within the Illinois Department of Human Services, and they provide a home services program which helps people with disabilities remain independent and avoid having to go into a nursing home or institution. And they also administer the vocational rehabilitation program. And so for purposes of the Client Assistance Program, we are working with individuals who receive the vocational services through DRS. So who qualifies for DRS vocational services? Well, fundamentally, an individual who wants to apply for DRS services has to want to work. Employment has to be a desired income. And that individual also has to have a significant physical or mental impairment that impacts or makes it hard for that individual to work. And you'll notice that this eligibility definition includes high school age and transition age students who are preparing to enter the workforce or looking for part-time employment. And in fact, one of our CAP advocates here at Equip for Equality is a member of the Special Education Clinic, and her work has largely focused on youth and transition services. So it's great that she'll be doing this work as an advocate with the Client Assistance Program. So if you'll recall, I talked about kind of the lesser known aspect of the Client Assistance Program in providing advice about and information about rights under Title I of the Americans with Disabilities Act. So through the Client Assistance Program, we can help answer questions that you may have about disability disclosure. How do you do this? When should you do this? What are kind of the pros and cons of doing so? Requesting reasonable accommodations, or challenging discrimination issues in the workplace. The Client Assistance Program can also help you draft requests for accommodations. We have some templates that you can use to put that together. We can review your drafts and offer feedback. And we can generally utilize our experience that we have with employment issues here at Equip for Equality to help you brainstorm solutions if you're dealing with a particularly difficult employer. So we've talked a little bit about the client assistance program. How do you get in touch with us? So you can contact the client assistance program by calling the dedicated phone number, which is 855-452-2725. You can also send an email to the CAP designated email address, or you can visit our website, which is, there's a CAP portion of the Equip for Equality website. And we're working on a series of fact sheets and sample letters and worksheets that will be available in English and Spanish. And we're also working on some ASL videos and making sure that the materials are provided in other languages as well. And you'll also see that there's a calendar of our upcoming trainings. You may have seen this training advertised on that calendar, but we'll post trainings in the future. So now I'm going to turn it over to Hannah to really dive into the substance of our employment focus today. So Hannah, take it up.
Thank you, Megan. So what we wanted to talk to you all today is really kind of do a deeper dive on your employment rights as people with disabilities, in particular, your reasonable accommodation rights. So when we're talking about rights for people with disabilities, reasonable accommodation rights, we're often talking about those rights as being a part of a law called the Americans with Disabilities Act, or the ADA. And through this presentation, Megan and I will likely reference the ADA multiple times. We'll be talking about this kind of through the lens of the Americans with Disabilities Act. But I think it's important to note that these rights to accommodations, these rights as a person with a disability in the workforce, aren't just within the ADA. There's also the Rehabilitation Act, which is a federal law that that's very similar to the ADA. It applies to the federal government or employers who receive federal funding. There's also a state law in Illinois called the Illinois Human Rights Act that has very similar rights. And there's smaller local laws, the Cook County Human Rights Ordinance, the Chicago Human Rights Ordinance. All of those laws work to protect people with disabilities in similar ways. It's just a bit easier to frame this in the context of the Americans with Disabilities Act, because I feel like most people are most aware of that law. So what are the goals of the ADA? What is the purpose of these laws that protect people with disabilities in the workplace? Well, the big one is non-discrimination, helping prevent people with disabilities in the workforce or who are applying for jobs from experiencing discrimination from employers, providing people with disabilities equal opportunities to the workplace, which is kind of where reasonable accommodations come into play, and also helping people with disabilities find and keep jobs. Unfortunately, there's still, even with the ADA, which has done a lot of great work for people with disabilities, there's still a big disparity between people who don't have disabilities and are employed and people with disabilities who are employed. So that's kind of some of the things the ADA is meant to help with. So who does the ADA protect? Well, obviously, given this presentation, we know the ADA protects people with disabilities. There's kind of a complicated legal definition of what constitutes a person with a disability, but essentially, at the end of the day, it's a little more simple than the definition makes it seem. If you have a physical condition, a mental health condition, a medical condition that has a significant impact on you, you have a disability under the law, and you're protected by the ADA, and you have rights to things like reasonable accommodations under the ADA. So like most other civil rights and anti-discrimination laws, the ADA is in place to prevent discrimination in all aspects of employment. So like other civil rights laws, this applies to job applications, hiring, firing, the benefits and compensation you get, any promotions or advancements, training, really every aspect of employment. Where the ADA is unique, though, from other civil rights laws, where the ADA gives more rights to people with disabilities, is in specifically under the ADA, refusing to provide a reasonable accommodation is considered discrimination. So the ADA provides the right to accommodations within the law. Also, what makes the ADA unique is that certain medical exams and inquiries are also considered discrimination under the law. We're not going to get as much into that. We're really going to focus in this presentation on reasonable accommodations and the rights that the ADA gives you in terms of getting accommodations at work. And I'm very sorry about my cat. She likes to be involved in presentations. Okay. So what is a reasonable accommodation? I feel like I've said this word many, many times, but we haven't really gotten into yet what exactly that is. As I said, under the ADA, you have the right to reasonable accommodations at work as a person with a disability. What that means is employers have to give applicants and employees a reasonable accommodation if they need one for their disability. And we kind of look at reasonable accommodations in 3 different ways. One, you can get an accommodation on an application or interview. You can also get an accommodation to help you do your job, and also so you can have equal access to benefits and privileges of your job. And I'm going to get deeper into those things in just a sec. Just a quick overview of what an accommodation is. I'm sorry, I feel like I'm missing a slide. I apologize for that. Okay, well, since I can't find that slide, I'm just gonna get into it right now. So, as I said, your ADA rights as a person with a disability kind of start before you even get a job. As an applicant or someone going through the interview process, you as a person with a disability still have the right to accommodations at work. This can mean a variety of different things, and I can get into those later, but just because you haven't actually started working yet doesn't mean you shouldn't be able to get accommodations when you're applying for or interviewing for jobs. When we think about reasonable accommodations, and this is definitely true of employers, this is really what they tend to focus on because it's the big thing that people need accommodations for. I would say the majority of people who look for accommodations at work are because of this, is to help you do your job. Unfortunately, like a lot of the world, the workplace is often set up to be kind of inherently inaccessible for people with disabilities. There are a lot of things about the workforce that may cause problems for people with disabilities to be able to do their job there. So the point of a big purpose of the ADA and reasonable accommodation rights is to change how a job is traditionally done so that you, a person with a disability, can do the job. That's what we usually think of when we think of reasonable accommodations. Another area of accommodations that I don't think people think about as much, and employers don't really seem to understand this as much, is that you are also entitled to reasonable accommodations so that you can experience the benefits and privileges of your job. And this is different from accommodations to help you do your job. Let's say you're a person who is deaf and you need access to an ASL interpreter at a meeting. That meeting is a part of your job. It's important that you're there. You need to go to that meeting to do your job. You get the interpreter as an accommodation, so you have access to that meeting. Benefits and privileges of employment is different. When we think about this, maybe you can do your full job at work. You're absolutely able to do your job. You don't need accommodations for that, but there's something about the job that makes it more difficult for you, or makes that you're not getting the same access to, even though it's not the job itself. There's a couple examples for how this could work. One, let's say there's a holiday party, right? The holidays are coming up right now. Let's say there's a holiday party and your employer is having this party, and you're a person who uses a wheelchair, and they have this party at a location that's not accessible to you. There's no ramp, so you can't get into the building. Going to that party isn't an essential part of your job that you have to do in order to do your job, but it is a benefit of that job. And you should be allowed to go to the party the same as anybody else. Just because you have a disability doesn't mean you shouldn't be able to go to that party. So that's an example of a benefit of the job that you should have that everybody else has. Another example of this, and I think that for me, the best way to describe this is to use an example. And this is a real client I had, this is a real situation. So in this case, I had a client who was a veteran. She had PTSD and she used a service animal. She wanted to be able to bring her service animal into work so that the symptoms of her PTSD wouldn't be as bad at work, to help alleviate panic attacks, her anxiety, that kind of thing. Now she could completely do her job. She was great at her job, but without her service animal at work, She was very anxious all the time. She had more panic attacks. It made it difficult for her on a day-to-day basis. Even though she could do her job, she could and did ask for a reasonable accommodation to bring her service animal to work. And the way that she was able to support, needing that accommodation is because everyone at work who didn't have a disability, right? All of her colleagues without disabilities got to go to work without experiencing increased anxiety and panic attacks. Well, that's a benefit and privilege of their employment that they have that she as a person with a disability didn't have. So to have full access to those benefits and privileges of her employment, having a service animal there was a reasonable accommodation. Okay, so we also, taking a couple steps back, we talked about how you can potentially ask for accommodations when you're applying for jobs or going through interviews. And this is absolutely true. And just kind of wanted to go through some examples of this because I don't know that people always think about accommodations at this stage of the job process. So let's say, there's an online application and you need a paper copy because of your disability. That's an accommodation you can ask for. Maybe you have a vision disability and you need the application in large print or braille or an audio file. Those are all accommodations you could request. Maybe, sometimes employers have exams and stuff you have to do before they can hire you for the job. So maybe you need to answer those questions orally or have someone write down the answers for you instead. That could be an accommodation. Maybe their office isn't in an accessible location for the interview. You need that. You can ask for that as an accommodation. And again, going back to if you have to take some sort of test, maybe you need extra time or extra accommodations for that test. Those are all accommodations you could ask for. Also, a sign language interpreter at the interview, bringing your service animal to the interview, that kind of thing. There's no set list for accommodations that are considered reasonable. Really, it really depends on what works for you and what works for the employer. These are just some common examples that we see. Okay, so getting kind of deeper into reasonable accommodations, it's not always a quick, easy fix of like, what's going to help me work. Sometimes people with disabilities don't even really know. They just know they're having problems at work. So it might take you some time to figure out what accommodation works for you, isn't going to cause big problems for your boss. And again, there's no one size fits all for accommodations. So two people with the exact same disability may have completely different accommodation needs, and that's okay. Every situation, every employee, it should be looked at on a case-by-case basis. What do you need as the employee with your disability? And it might be different from what somebody else needs, but it may also take some time for you to figure out what's going to work for you, what's going to work for your employer. So the goal of requesting accommodations overall is to find the right accommodation for the employee's disability, along with their job and the employer's needs. I just want to throw in a quick plug right now for a fantastic organization called the Job Accommodations Network. Now, again, like I said, sometimes you may not know what accommodations you need at work because this isn't something you've had to deal with before. It's a new issue or maybe it's a new disability. You're just not sure. The Job Accommodation Network is an online source. It's free. They have experts you can talk to. The website is great and thorough. And for like every disability you can think of, there's different accommodation suggestions, but you can also call them and talk to the employees there, explain your disability, explain your job, explain the trouble you're having at work, and they can help you figure out accommodations that might fit. So I would highly recommend the Job Accommodations Network, or JAN. The website is on this presentation, but it's askjan.org, askjan.org. It's a great resource for figuring out accommodations. And here's some examples of reasonable accommodations. Again, this list is not comprehensive. It's not every accommodation that ever exists. There can be completely different accommodations for different people. Really, anything at the end of the day can be an accommodation if it works for you. It just really depends on you and your situation. These are ones that we kind of see a lot of. So, modifying the workplace or the building to make it accessible, building ramps, widening doors, things like that. Giving a sign language interpreter for trainings and meetings, installing screen reading software for people with vision disabilities or learning disabilities, Maybe you need a flexible schedule because of how your disability impacts you, or because of when you take your medication. That could be an accommodation. Maybe there's some not essential job functions that you have a hard time doing because of your disability. Removing those could potentially be an accommodation. Maybe you need extra breaks to take your medication, or to, take some time to yourself. That could be an accommodation. Sometimes job coaches, so people who go with you to work to kind of help you figure out how to do your job. Those could potentially be accommodations. I apologize, my dog is barking in the background. Maybe you need directions in writing, or maybe you need directions verbally. Those are two completely separate things, but they could be accommodations depending on what you need, even though they're complete opposites. Maybe you need your supervisor to make you a weekly to-do list, or meet with you weekly to go over things. These are all kind of ideas for accommodations. A couple other things on here I'm going to get into more detail, but again, this list is just things we commonly see. It really just depends on what you need and what works for you in a situation. But there were a couple of accommodations I wanted to discuss in more detail, because I think that these tend to come up more frequently, especially recently given the pandemic. And they're a little more tricky and a little more nuanced. So we wanted to do a deeper dive on these particular accommodations. So first, this is a big one. Remote work or telework as an accommodation. I think since the pandemic, it has become, more and more common that we're seeing employers allow people to telework, which can be really great for all employees, but especially for employees with disabilities. But we're also seeing a lot of pushback from some employers on allowing people to continue telework. Maybe they let people telework during the pandemic because they didn't have any other choice, but now they're really pushing people to come back. So I think it's important we talk about telework as an accommodation, and telework may absolutely be a reasonable accommodation. The way we figure out if that's the case, though, is we have to look at the job and decide, can you do all the essential parts of that job from home? If the answer to that is yes, then telework is very likely a reasonable accommodation. However, if there are parts of the job you can't do from home, maybe again, your boss let everyone do the job from home, but they weren't doing their full job, or there's just some things you have to do in the office, you can't, or somewhere else, you can't do them from home, then full-time telework probably isn't reasonable as an accommodation. Unfortunately, you have to, in order to get an accommodation, it has to allow you to do your full job. You can't get accommodations that take away essential parts of your job. Now, maybe that means in those situations where you can't do your full job from home, maybe part-time telework is reasonable, but full-time telework may not be reasonable. Again, I said this before, but even if an employer excused employees from certain job tasks during the pandemic, they don't have to continue to do that now that kind of the world's opening back up again. So I would say overall, the pandemic, while, objectively horrible, has had one positive impact on the community, on kind of the workforce for people with disabilities, is that telework is becoming more common and more acceptable and more understood, especially as an accommodation. Prior to the pandemic, it was very difficult to get telework as an accommodation. Most courts did not think it was reasonable. But we think this situation is changing since the pandemic, and we think it's going to be easier for employees to successfully request telework as long as they can do all the essential parts of their job from home. Something else that may come up in your job, maybe because of the pandemic, maybe not, but is reassignment. Now, some people, maybe because they have a new disability, or because their disability has progressed, or their job has changed, or they have different symptoms of their disability now, might come to a point where they just can't do their job anymore. No matter what accommodations you have in the job, nothing's going to work. Nothing's going to actually allow you to do the job that you were originally hired for, that you're currently doing right now. And that puts people in a bad situation, right? It seems like maybe the only other option is that you have to quit working, but that's not necessarily true. Reassignment can be a reasonable accommodation under the ADA. So it's typically considered an accommodation of last resort, which means if there's no other accommodations that will allow you to return to work in your current job, then you can ask for reassignment. there's some caveats here. So to get reassignment, there has to be a vacant position. So there has to be a position open. You have to be qualified for that open position. It has to be safe for you to work in that open position. And this work can kind of get a little bit tricky. So as long as, there's an open position, you're qualified for it, you likely should be able to be reassigned. The only exception to that is if you are also in a union, and that union has a bona fide seniority system. So, the way seniority systems and unions typically work, the people who have been working there the longest get priority when it comes to transfers and being reassigned to other positions. If your reassignment interferes with that seniority system, then it's not going to be considered reasonable. In that case, the union contract kind of supersedes the ADA. But if that's not an issue, your seniority system doesn't interfere, you're not in a union, and there's an open position you're qualified for, then a reasonable assignment may very well be a reasonable accommodation that you can get so that you can continue working. I think an example of this might be, let's say, you have someone who was a nurse and now they have disabilities that really impact them physically. They can't do the physical aspects of the nursing job anymore. There's no accommodations that's going to let them do that, but they want to keep working. Well, maybe there's an open position in administration where they'd work in an office and do those aspects of the job. That could be completely reasonable accommodation to be reassigned to that position, as long as there's one that's open and they're qualified for it. And then the last accommodation I wanted to do kind of more of a deeper dive on is leave as an accommodation. So employees with disabilities may be entitled to some leave as an accommodation under the law. Unfortunately, taking this leave isn't job protected. It's also not paid, which is kind of a bummer. And in some courts, in particular, the courts that kind of rule over Illinois, so this is the case in Illinois. It's not in every other state, but in Illinois, courts have found that more than a month of leave is not a reasonable accommodation. So some leave could be considered reasonable, but if you ask for more than a month of leave as an accommodation, that's not going to be considered reasonable, and an employer can deny that. Again, like I said, this leave is also unpaid. There are other laws. You may be familiar with the FMLA, the Family Medical Leave Act, that provides more options for leave. You have to be eligible for that. But if you're not, or that's not going to work out for you, or you've already taken that, you may be entitled to some leave as an accommodation under the ADA. I think it's important to note too, this leave as an accommodation only applies to employees with disabilities who need it. Unfortunately, you can't take leave as an accommodation if you have a family member with a disability and you have to take care of that family member. The employer doesn't have to give accommodations for that situation. It's only for the employee themselves with the disability who needs leave. Okay, so I think at this point, I'm going to turn it back over to Megan. Sorry, just one second. Okay.
Great, thanks, Hannah. So we are now going to talk more since Hannah provided an excellent overview of the entitlement to reasonable accommodations under the Americans with Disabilities Act at those different stages in the employment process. We're going to talk a little bit more about what does it look like for someone who needs to request a reasonable accommodation. That's a question that we get a lot here at Equip for Equality, both with the Employment Rights Helpline and also with the Client Assistance Program. So we think it's definitely worth a deep dive. So once you've figured out that you are a person with a disability and you need to request an accommodation, you can do so. The law does not require you to do so in writing. An oral or verbal reasonable accommodation request is perfectly valid. But I think as the lawyers within us, we always advise clients to do so in writing, just so that you have documentation and a paper trail. That's always helpful. So you don't need to be a lawyer and have, all of the legalese and the legal knowledge to write a reasonable accommodation request. But we have found that it is really helpful when an employee uses the terms reasonable accommodation and ADA. in that request, just to really alert the employer at the outset that what they're asking for is for a disability-related reason. So at the Equip for Equality's Employment Rights Helpline and with the Client Assistance Program, we will have templates. As you'll see on the next slide, we actually have a template of a reasonable accommodation letter that you can copy and paste and send via email or regular mail to your employer. So in general, you should send this accommodation request either to your supervisor or the Human Resources Department. And again, we recommend doing so in writing and then following up in writing about the status of your reasonable accommodation request. So this slide that you see here is a template letter, and it really illustrates, we hope, how simple it is to make this accommodation request and that you don't have to use any, fancy jargon. But one of the areas that we talk about and advise clients about is disability disclosure, right? How do you do that? When should you do that? And it's important to know that if you're requesting a reasonable accommodation, that disability disclosure is required, right? So in this sample accommodation request to either a supervisor or Human Resources Department, you're identifying that you have a disability and what that is. And because of that disability, that you're seeking reasonable accommodations under the Americans with Disabilities Act. And it's perfectly fine in this letter to include what accommodations you need, if known, right? But it can also be generic and just invite the conversation. You don't have to know exactly what you need at the outset. And so a critical question is, okay, I've submitted this accommodation request to my supervisor. Now what? What's supposed to happen? So the law requires employers to engage with the employee in what's known as the interactive process. And so that's the dialogue that Hannah was talking about in the analysis of whether a particular accommodation would be reasonable and feasible. So as they said before, whether a particular accommodation is reasonable is so fact specific, right? So a particular accommodation may be reasonable in one employment setting, but not in another. So that's why the law requires this individualized interactive process to figure out, given the employee's specific disability, as well as the type of employer situation and the demands of the job, what is reasonable in this given situation. So an employer is supposed to give primary consideration to the accommodation that the employee has requested. But the law requires an effective accommodation, not necessarily the preferred accommodation. So that's the purpose of this interactive process, to go through and figure out what will be effective, which may or may not be the preferred or requested accommodation. And if someone asks for an accommodation, an employer can't just say no and stop the conversation. The interactive process requires the conversation to continue. And I just want to give a plug, as Hannah already did earlier, about the Job Accommodation Network as a wonderful tool both for employers and employees to really brainstorm accommodations that may be feasible. And another important thing to know is an employer may ask for reasonable medical documentation to support the need for an accommodation. Now, an employer is definitely not allowed to have access to your entire medical file, your entire medical history, but it is reasonable for them to request documentation that explains your disability a little bit more and the need for the particular accommodation. And I think an important point here is that once the accommodation has been granted or implemented, there are still responsibilities on the part of the employer to continue to make sure that that accommodation is applied consistently and implemented as it should. But also, what's really neat is that the person with the disability, you're not locked into that accommodation forever. So your disability may change. You may get a new disability, or it might be that the particular accommodation that worked at one point is no longer as effective. So this interactive process is not a one-time and done. It's ongoing on both the part of the employee and the employer. So you can absolutely request new accommodations or different accommodations at a later date in your employment. And we generally recommend, if the need should arise for new accommodations or different accommodations, that you do so in a timely manner to the extent that you can before any performance issues arise. So now I will turn it back over to Hannah to sort of wrap up some accommodation pieces and also to really show how these theoretical concepts kind of work in practice with some case examples.
Yeah, awesome. Thank you, Megan. And we looks like we're doing well on time. So we just want to, make sure there's enough time. If anyone has questions at the very end, you can put them in the chat or the Q&A now, or you can just wait to the end and ask any questions for, if there's some gaps in what we covered, or you just want to talk through some things. Just wanted to do some kind of last minute important things about accommodations. Some of this is what we've already covered, but just these are things that are kind of, we feel like are important to remember. As Megan just said, the accommodation that your employer gives you has to be effective, right? Like they have to try and figure out how to give you an effective accommodation. Unfortunately, it doesn't necessarily mean that they have to give you the exact accommodation that you asked for or the best accommodation. Sometimes if they found a cheaper option or an easier option, as long as it works for you, they can give you that accommodation. But it's important, as Megan said, to let your employer know if the accommodation they provided isn't effective, because if it isn't, then they may have to go back to the drawing board and figure out, okay, maybe we do have to give them the accommodation they actually requested. Something also to keep in mind, personal devices are not considered reasonable accommodations. So a personal device would be something that you use in maybe at work, but something that you also use outside of work, maybe primarily outside of work. So for people with hearing disabilities who may use hearing aids, an employer wouldn't have to pay for hearing aids for that person because that's something that's considered a personal device that you use outside of work. So when we're talking about accommodations, we're only talking about things that are used at work to allow you to help you do your job. We've been talking solely about the rights of people with disabilities at work and what those rights are. And reasonable accommodations are definitely a huge part of that. But the ADA and other anti-discrimination laws for people with disabilities cover more than just people with disabilities, actually. And we don't need to get too far into this, but the ADA provides some protection for people who are regarded as having a disability, as well as people who are associated with people with disabilities. So if you're being discriminated against at work because your employer thinks you have a disability, let's say they think you have diabetes, you don't have diabetes, but for some reason they think you do, and they fire you for that reason, you're protected under the law, and you could potentially, pursue a complaint against them because of that. But even if you're regarded as having a disability, you don't actually get accommodations. You can only get accommodations if you actually have that disability. The same is true for people who are associated with people with disabilities. So let's say your partner has a disability, your child has a disability, your parent has a disability, but you don't. If you're fired because your employer finds out that your child has a disability, you're protected from that discrimination under the law. And again, you could maybe pursue a complaint against them, but you don't get accommodations just because the other people in your life have disabilities. You have to have the disability to get the accommodation at work. Another thing to note, employers aren't prevented by the law from giving extra accommodations. That's not something we see as much. We see more employers just trying to provide the bare minimum of what they have to. But if they decide to go above and beyond and give you all the accommodations you want and, anything and above and more, they can definitely do that. There's nothing in the law that prevents them from doing that. It's just not something we see as much, but it can happen. And then this really important thing, and Megan already went over this really well, but once, when you're thinking about requesting accommodations, the important thing you really, your job first and foremost is to make that known, make that clear, ideally in writing that you need accommodations, you're a person with a disability. After that, it triggers this interactive process where your employer has a lot of responsibilities and has to work with you to try and figure this out. You also have responsibilities to work with them to try and figure that out. But once you make that request, it really starts this process to get you to the point of getting an accommodation. So we do have one kind of scenario example that I just wanted to talk through with everyone, because I feel like this it's sometimes good to put what we've been talking about in kind of more abstract terms into like a real scenario and think about how we would handle that and what we think about this person's rights and how, what our advice to them would be. So in this case, we have Stephen, and he works as a marketing analyst. He has a learning disability, and this makes it really difficult to take notes during staff meetings, but those staff meetings are really important and he needs that information. So he verbally tells his supervisor he needs a note taker because he has a learning disability. His supervisor then asks him to sign a general release for medical documentation. And then later, Stephen finds out the company actually wants it to purchase computer software that can take notes. This is a cheaper option for the company, which is why they want to do it. So he contacts CAP, Equip for Equality, and asks, did I make an accommodation request? Should I follow up? Do I have to provide this general release for medical documentation? And is the company allowed to give me this software instead of the note taker, which is what I asked for? And I think this is all these questions are things we just covered in this discussion. So first of all, Stephen absolutely made a request for reasonable accommodations. He said he had a disability. He said he needed help during the meeting because of his disability. And he even picked out a specific accommodation that he was asking for. Even though this was a verbal request, he made a request for accommodation. Now, as Megan said, we do think it's really important to follow up in writing and make that request as well. And so that way, just to be safe, the supervisor can't say, no, you never asked me for that. You have it in writing in an email that says, I'm requesting reasonable accommodations because of my disability under the ADA, then, you have proof that you did ask for that. And I would have Stephen send that to his supervisor and probably to HR as well. Now, as Megan discussed, his supervisor can ask for medical documentation because Stephen's disability isn't obvious. It's not obvious he has a learning disability. However, a general release for all your medical records is not reasonable. Employers cannot ask for that. It's none of their business. That's not what the law says they get. All they can ask for is limited to confirming he has a disability and needs accommodations. And sometimes employers have their own forms for these kind of things. Sometimes you can have your doctor write a note. But in Stephen's case, I would suggest that he push back and say, can I give you a doctor's note instead? Do you have a form he can fill out with specific questions about my disability? Because he doesn't have to provide all of that medical record, all those medical records and documentation. And then kind of the final question, is it okay that his employer wants to give him a note taker instead of, computer software instead of a note taker? And the answer is maybe it could be okay. A note taker may be the best accommodation for Stephen, but if this computer software works and is effective and effectively takes down the notes and gives Stephen all the information from the meeting, then it's okay. Then they're allowed to give him an alternative to what he requested. So what I would tell Stephen is, try out the software, see if it's effective, see if it works. If it works, then great, that's fantastic. If it doesn't, then you notify the employer that, this wasn't sufficient. And then the employer may have to rethink things and may have to provide that note taker to ensure they're giving Stephen an effective accommodation. Okay. The very last thing, just to make sure everyone has it, here's some of the direct contact information for the client assistance program. We have the phone number, email, and our website linked here. And then also our employment rights helpline has its own number. But kind of regardless of what number you call, who you email, if you let us know this is about employment issues or vocational rehabilitation services, we'll figure it out. We'll get it directed to the right people, and we can help you out. Okay, so now I think I'll exit out of this and then we can open it up to questions if anyone has any. Let me see, there is something in the chat. Oh no, I think no, let's see. Okay, well, Yeah, we'll just hang out here for a little bit, see if anyone has any questions or any comments would be great as well. And we really appreciate all of you coming out and taking your time here with us today. I think, oh, let's see. Can we talk about common questions we get on the helpline? Yeah, absolutely. So I would say the majority of questions we get for the employment helpline are about accommodations. And that's, I think, why we thought this was such an important presentation to have. I would say at least half of the calls we get are about accommodations. What are my accommodations rights? How do I request them? My supervisor doesn't want to give me an accommodation. You know, I think that's a lot of what we talk about with clients and help them with. You know, in the pandemic, I've seen a lot more issues related to telework, related to masking and protective equipment at work, that kind of thing. But then we also get calls about, you know, should I disclose my disability? Or I feel like my employer's sharing my medical information with people. What are my rights? Or I'm being harassed at work because of my disability, or retaliated against because I requested an accommodation. Like, how do I handle that? What do I do? I'm being, you know, I was terminated because of my disability. What are my rights? What can I do next? And so those are all kind of issues that we see and that we can help with and provide guidance on. But I would say, you know, the majority of questions we get are about accommodations at work.
And Hannah, there's another question in the chat from Rod asking, is this for existing employees or for candidates also? I'm assuming the question is meaning, is the employment rights helpline available to folks who are working and looking to work? If that's not correct, Rod, would you either type in the chat or let us know if we don't understand your question?
And if that is what you meant, yes, like there are, Equip for Equality, the work we do, the help we can provide you about these things is for people who are applicants and for people who have jobs. And the majority of what we were talking about in this presentation as well applies to you. You know, like certain situations we discussed can only come up if you're an employee, but your rights to accommodations exist before you even get a job. It's for candidates as well. But if you're trying to look for help as a candidate, you can contact Equip for Equality, absolutely. All right. Any other questions at this time?
And
okay.
Hannah,
sorry.
we have one.
We have one other.
Oh,
I'm gonna authorize Rod to talk because
okay.
yeah, so we'll see. Okay, hang on.
Yes, can you hear me?
Yes.
Yeah.
Okay. Yeah, thank you. My question, was and you kind of answered. Are these rights just for existing employees or for candidates? But my follow-up. So if there's a candidate that is qualified to do the job, say a front desk clerk, just hypothetically, for example, but the candidate has physical limitations and the candidate needs, for example, like a walker, one of those things that you can walk around and kind of sit in. She needs that for her mobility to move around, he or her. So hypothetically, if an employer told this hypothetical candidate, well, you should look to work elsewhere because of your need to use a walker, that doesn't go best with our space, so you should probably look at other locations that have more open space. Would that be like, how do you process that? And thank you.
Yeah, I think that would absolutely be a problem. I mean, that to me is just kind of very obvious disability discrimination at the interview stage. I mean, it doesn't sound like that person needed an accommodation at the interview, but it looked like they were essentially turned down from a job specifically because of their disability, which is not allowed under the ADA. Now, if let's say she had gotten the job and then, expressed, I need to be able to use my walker at work, and they had said the same thing at that point, I think the employer would have an obligation to consider, like, what can we, like, first, can we, we should allow her to try this out probably. I think, you know, they shouldn't just assume it's not going to work. But if there are some issues with the space that can be fixed, then they should probably making those fixes as an accommodation for that person's disability. Given this person hadn't started working yet, I think to me, it's just kind of a clear-cut example of discrimination in hiring.
Thank you. And thank you for the information today.
Yeah, you're welcome.
And
We
then,
do- Oh, yes,
oh,
sorry, go ahead.
sorry, go ahead.
Yeah, so we have a question. Do you have any suggestions on who to contact first to request an accommodation, supervisor or HR, and why? Yeah, so I would say first, if your employer has a policy on requesting accommodations, look at that policy and follow the policy. I kind of think it's better to reach out to both. One, because in my experience, sometimes supervisors don't, or to reach out to HR first. Sometimes supervisors don't always know like what accommodations are, what they like, they don't know it as well as HR should. HR, you know, ideally is going to be the entity that's trained on this, understands the ADA, understands accommodations. So I kind of personally think going to HR is a good idea. But if the employer has their own policies for this, let's say the policy is ask your supervisor, the supervisor will then go to HR, then that's totally fine. I would say ask your supervisor first. Or both. Let's see, I think oh no, it's just, thank you, you're welcome. Oh, and I have my hand raised for some reason. Okay, are there any other questions at this time? It doesn't look like it. All right, well.
Thank you again. Sorry, Hannah, I didn't mean to interrupt
Oh
you.
no, go ahead.
Well, I was just going to remind folks again that they will receive the PowerPoint slides and that this webinar is being recorded or has been recorded. And the webinar and the slides will also be on Equip for Equality's website. So you'll have access to the materials with the phone numbers and everything. And thank you so much for taking the time out of your day to join us.
Yeah, thank you so much, everyone. We really appreciate it. Have a wonderful day.
Take care. Bye.